and the next panelists will be coming up. As they're making their way up here, I'd like to take a point of privilege. You've learned a lot already about problems and visions. You've learned a little bit about what the task force is doing, but understand that this isn't necessarily an opportunity to sit and listen. This is an opportunity to be involved. So virtual participants, this is your chance to email over using the form questions, and those sitting here toward the back, your microphone is over there. I offer you, all of you, the opportunity to ask some questions. Don't hesitate to take that chance before our time is up, because we only have 30 minutes per panel. And panelists, I believe you are here. I'm Julie Fershtman. I am a past president of the State Bar of Michigan. With us is a distinguished panel of Dean Joan Howarth, Dean and President of Cooley, Don LeDuc. Dean Howarth is from MSU Law. Mwanaisha Sims, seated in the back, and we have Patrick Ellis toward the front. The problem that we're going to be talking about is crisis for new lawyers and new challenges for experienced lawyers. And each of you has an interesting perspective on the task at hand. So why don't I get started, and let me target my first question to Dean Howarth. Dean, what do you think in general about clinical opportunities in law schools when we talk about the crisis for new lawyers, practice-ready law graduates? As the Dean of MSU, do you believe that a program like a clinical opportunity offers any benefit to law students? And is this something that the legal educational system should be focusing on more going forward?
Sure, absolutely. First of all, there's no credible, let alone accredited law school can operate without having robust, ambitious clinical programs, because we are a professional school, we're not a graduate school, and the profession for which we're educating requires that its newest members have, for example, met and worked with a client. That's the importance of clinical education. So one of the aspects of that I've been thinking about and was really encouraged by in the work of this whole project was to notice, as I have noticed, that the current licensing mechanisms that we use are in fact very much pushing an attention against the growth of clinical and other kinds of experiential opportunities in law school. Because when you think about it, the licensing paper and pencil tests that we're using, which virtually everybody, almost everybody in our profession has had the same sort of experience, right? And we think of it as a rite of passage, and it's an on-off switch, and you go from 0 to full through passing some paper pencil tests in a few days. The problem is the set of skills that are tested are very, very narrow. So we're really only licensing testing on certain kind of rule memorization, legal analysis, and issue spotting. So what I was, I think, most excited about was the discussions that this group has had related to some changes and in some ways more ambitious licensing. And one idea that I think has a lot of merit is to really just fix the timing. We could take care of the legal knowledge and analysis part, the MBE, the multi-state part of the licensing test, really after the first year, base it on first-year courses. Once a student is done with that part of the licensing, then they can get on to the practice-ready part of their education and specialization and doing the clinics and learning how to take depositions. So I think that a little bit of switching up could make Michigan in the forefront of figuring out how to do a better job to protect consumers by having potentially a wider range of skills that are measured and that we license on. You get rid of the requirement now, which adds to the cost of legal education and is a burden on the opportunities for clinics. Right now, we have to think about it. At the end of law school, we have to go back and have everybody focus again on those basic courses and on exam taking when they should be out representing clients. So I think that could be an adjustment that would be really, really terrific for Michigan to investigate.
Let me explore that for a moment, because one of the topics that was discussed within the task force was whether we should consider a staggered bar exam instead of the big crash course over a couple of days, offering it during the law school process, taking it a little further from what you've offered with the MPRE. Professor, and well, Dean and President LeDuc, what do you think about the concept of a staggered bar exam for law students that would offer an opportunity to be tested while they're still in law school?
Well, I think that, are we ready?
Mike is catching up.
I was speaking quickly. The problems are, in my view, more pragmatic. It's how would you administer that complex approach with students who also have to be undergoing additional education at the same time. I like the concept of it personally, but I at a school like Cooley, where we go year-round, it is hard to fit these into the basket that's more structured for the traditional 2 semesters on and summer off approach. So there are some practical problems with doing that. I totally agree with Dean Howarth about the need to change the memorization part, which is the issue spotting, and all of us in this room probably knew more about the law in general the day we took the bar exam than we could ever hope to know again, because we tend to head into our own specialties or whatever area of interest our clients bring to us. So the functionality of the bar exam, I think, has perhaps served its time, and we need alternatives. And I think we also, if we want to keep with the idea of practice ready, we need to give more encouragement to the things that are practice ready, including, Joan used the term that some of us may not quite understand the expanse of, but almost all the schools in the country today also do externships, which bring the bar and the profession into the teaching of young lawyers about how to practice law, and that is very widespread and certainly very different from the times that most of us experienced in our own legal education.
Let's shift gears and let's turn it over for just a moment to our slightly younger lawyers here. And let me shift over to you, Mwanaisha, and then we'll ask a couple of questions of Patrick. Let's talk a little bit there about practice ready. As somebody who is of the younger age of lawyer, what do you think that employers look at as necessary in the short term for young lawyers?
Well, a survey that all of Michigan we participated in, you were sent, a lot of employers, honestly, for the first one said keeping confidentiality, believe it or not, in the short term. So they're concerned with new lawyers not keeping confidences. The second one, believe it or not, was arrive on time. Then the third, honor commitments. The fourth being treat others with courtesy and respect. 5, respond promptly. And then a strong work ethic. Now these are called soft skills. And you're thinking, okay, now we're in law school, can I learn how to keep confidentiality or arrive on time? But going back to externships, internships, and you're working with clients, you can learn that throughout law school. It may not be a class you teach, but you start learning those responsibilities, and I think that's important. And those are what employers are looking for, new lawyers to come into the profession already knowing.
Let's shift gears over to Patrick, who's been sitting quietly over here. We've been talking about practice-ready graduates. We've been talking about law schools trying to meet the needs of students these days. We've been looking at what skills law students and lawyers, young lawyers, need. Let's shift over to you, because you have an understanding of alternative careers for lawyers. And keeping in mind that not every lawyer aspires to do transactional corporate work, litigation work in court, what do you believe, Patrick, are skills needed for people with law degrees who are seeking alternative careers in the law?
Well, I think Janet mentioned earlier that 2011 was sort of the bottom of the trough for legal employment and opportunity, and that happened to be the year that I entered law school. And in fact, I did want to pursue a traditional legal career. I was interested in litigation without really having a great understanding of what that meant. And as I progressed through school, and I was fortunate enough to have a number of professors, including Dan Linna and Renee Kanaki, who I believe are here today, who not only taught us, the students who were in these classes, not only taught us about the practice of law, but also what was going on in the legal economy and marketplace. And it was through learning about these things and learning that the shifting economy, the shifting needs of consumers, both, the consumers that we talk about, we've talked about a lot today, as well as, larger corporate clients or institutional clients. Learning that the shifts in the marketplace are opening up these opportunities for folks who want to still participate in the profession, who want to be members of the bar, but do something other than practicing law. And I think that the kinds of skills that I'll go back and say that I think there's sort of two paths for law students today. And I think the majority of students will still pursue and should pursue a traditional career in law, practicing law. Now that said, I think that it's great that they learn a number of these soft skills that are wanted by employers, but at the same time, understanding technology, understanding the business of law, understanding process improvement, managerial skills. These things are becoming more and more important, not only to hiring attorneys, but also to the clients that they serve. So it's important that attorneys are developing these skills as well as those kind of softer skills. But for those students who want to pursue an alternative career in law, these careers are increasingly requiring competency in technology, economics, mathematics, computer science, and I think that to the extent law schools can expose students to those things while still providing a traditional legal education, that sort of blend of skills, what's been referred to by a former classmate of mine and colleague today, Amani Smathers, this is a T-shaped lawyer. That is, you still have this deep understanding of legal issues and needs, but you also have this kind of shorter array of non-traditional legal skills, technology, math, economics, those sorts of things.
Well, let me turn back another question to both you and Mwanaisha, and then we'll leave the law school people here for just a moment. Whose job is it then? When we talk about practice-ready law school graduates, is that a term of the past? Because practice isn't what it used to be. Should it be incumbent on the law schools then, as you see it, as part of the educational process, to train and educate not just for traditional law practice, but to open up opportunities for the students in alternative types of legal work? What do you think?
When I first, these results came out, and keep confidentiality and things like arrive on time and speak professionally were some of the characteristics employers were looking for. I was shocked. I'm like, this is sort of kind of home training. Then you kind of develop it over time through experience. And in the discussion, I was thinking, well, how can a law school develop these type of skills? And I go back to saying externships, internships, mentoring with other lawyers, older lawyers in the professions, seasoned, and doing it early on in the legal profession or the law school, your law school career. I think it's extremely important because you should be able to keep a confidentiality. I mean, that's for our ethics here, in Michigan and just across the board. That's important, and you should know how to do that. But if you're not working with clients or if you're not having an internship until your very last semester, you may not learn that. So I think it has to happen early on. I think we do need to maybe start having credits go towards an internship or an externship and more clinicals in law school.
I too am surprised that the skills listed from that survey are those that are most demanded and expected by employers. It seems like those are all things, for the most part, that you should be learning in kindergarten. And perhaps some of the reason for that is because employers know not to expect real substantive legal skills. They just kind of have called that a wash, so they're going to settle for things like showing up on time. But I think that I wholeheartedly agree with that point, that exposing students to the realities of practice, to the realities of the business, and to the realities of the economics of the industry and the profession are absolutely key, as early as possible.
Looks like we have a question. Go ahead.
Yes, you do. Hi, this question is from Mwanaisha. Maya Watson, good to see you. I had a question about the clinical and mentoring that you talked about and how it's just as essential as some of the other skills that were on the list. Do you think that the general 3 years of law school, part of that time should be sacrificed for clinical study or practical activity that law students could participate in? So maybe shorten the amount of time in law school and spend more time in the workforce?
Maya, that's an excellent question. We've been spending a lot of time, hold that thought, on the issues involving new lawyers. If you can answer the question, keep your remarks. I'd like the panel to start shifting gears to challenges for the experienced lawyers, the older folks like me. So go ahead, briefly.
Briefly, I know law school, 3 years, right? You have the summertime to do a full internship. I think if you're able to spend part of your semester in school and taking classes, doing clinical work, and partnering also with a older attorney, I think you can help develop some of those skills, because maybe that older attorney can help mentor those type of skills and develop ones that seem like you should have learned maybe in kindergarten or throughout your life experience.
All right, as threatened, let's shift our focus for just a bit, and I'd like to ask this question of Dean Howarth. When we talk about the experienced practitioners, lawyers of a certain age, the marketplace is changing. We've already heard a little bit about it, and I can assure you the task force spent a lot of time looking at how the practice is changing. But the topic has come up about an option of alternative ownership structures for law firms. And it's been debated around the country. And I'm wondering, Dean Howarth, if you have any thoughts, and if you think that this is something that the bar should be thinking about.
I, of course, have absolutely no expertise, really, on the current issues related to financing of legal practice and financing the business of law firms, small, medium, and large. But what I have been what I have a sense of is that it's important for Michigan to look carefully at the variety of different kinds of options that are out there in the world related to ownership of law practices. As far as I can see, one of the problems right now for law firms is, in some ways, banks are heavily involved now with it's not the ownership, but the mortgaging of law practice. And so we're already in a situation where the sort of pure notion of the pressures are somehow, the business pressures are kept at bay because it's only lawyers who have clients always first. That's the basic principle, but I worry about us holding on to that principle when the rest of the world moves into creating opportunities for the delivery of legal services funded through capital, right, from businesses, from entities, from stores, from Walmart, from whoever it is, and with the globalization and technology and services available through the, off the cloud or wherever they're from, without knowledge of or caring about jurisdictional boundaries, I worry that our profession is going to be somehow losing the work that's at the core of our work because of not being quite willing to at least think about the possibility of what we would need to be able to do with high requirements of professional responsibility, but at least some consideration of modification of the ownership rules.
Appreciate that. I see we have a question. Quick thought for all of you sitting here wondering, how is this task force looking at the issue of alternative business structures with law firms and firms that have multidisciplinary components with CPAs and lawyers and other types of people joined together? Before anybody draws conclusions about where we're heading, I can assure you the task force is looking at it and has studied it, but by no means is there anything concrete that is being proposed at this time. It's simply an issue of study, and clearly there's a lot to consider. Let's turn it over to a question. Howard?
Okay, can everybody hear me? All right. My question is this, looking at your vision on the right and listening to what you've said so far here, what you're really saying regarding law school is this. Law school itself needs to change in terms of, for example, faculty. If technology, if marketing, if sales, if practice management are important, how can you have students coming out with those skills if you don't have anybody in law school teaching them?
I think that's a great question. Why don't we turn this over to Dean LeDuc? And that has become a question. Actually, somebody proposed it as one of our virtual followers who wants to know, should law schools be teaching law practice management as part of the regular curriculum? How do you respond to the questions?
Well, it's an interesting concept, and I'll tie it into something that's already been covered a little bit, and that is there's lots of interest in reforming law schools. Everybody has an idea about it. Most of the ideas are shaped by what we experienced in our own law school. Mine harkens back to Wayne State in 1967. Things have changed a lot since then. And the reality is practice management is taught, I think, in virtually every law school in the country. We are doing many of the things that reformers are claiming we should be doing, when in fact we're already doing them. So what I was struck by, and this is not limited to this group, but to other groups I've worked with, is one of the things that education is struggling with right now is what is it that the role that people want to have the law schools do or the educational entities do, and trying to do the reforms before we really find out what's going on. So from the law school perspective, this is an interesting task force, and I'll be happy to hear what they all have to say about where practice should be, because that will then instruct us as to what we're going to change in the law schools to prepare the students for that sort of endeavor. And I'll plead guilty to the premise of that last question. Law schools have traditionally taught the practice of the past. We learn from appellate decisions. Those take forever to come about and a long time to change. So the educational model itself could very well be changing, and the concept of what are we going to do with clinical education versus having first-year law school subject matters tested right then. Those things conflict with one another, and we need to find a way to settle on what it is that we're trying to do, and I think that comes from the definition of what practice is and what are the expectations, not just for whether the students will remember that they aren't supposed to blurt out what they've learned that day at work to their friends on Facebook, that what we need to do is centralize our focus as educational institutions on where is the practice going to be today and where will it be 50 years from today, because that's what we're preparing these young people for.
Can I also
Please do.
briefly respond? Sure. Our law school, Michigan State, all of the law schools now have a combination of full-time academic faculty and part-time faculty, because we need to have the expertise and the on-the-ground experience and up-to-date experience of practicing lawyers and judges. So of course we have to, and we all do, offer law practice management, and we use the expertise of leaders in the bar to be able to have the kind of professional education that we are really obligated to provide. Believe it or not, and this might be consistent with your memory of law school, but in my opinion, the intellectual part of law school, right, memorizing and figuring out the rule against perpetuities or whatever else it is that's the intellectual puzzle that you somehow think of as the rigor of law school, is easy compared to the work of legal education related to professional formation, development of the character and the identity of a professional lawyer, and development of the skills and practice abilities of a professional lawyer. That's just as important, in many ways, much more difficult to do well than the intellectual part that law schools have traditionally, especially historically, been focused on. We're all focused now, I think, on all three of those aspects.
We've only got about 2 minutes left. Question for the law school types over here, not the grads, but the deans who are seated here. The cost of legal education, some might say, compounds the problem because it's extremely expensive to be a lawyer, and with the debt, it affects the manner in which you practice law. Hold on. If you can answer very briefly, each of you, if you'd like, is the cost of a legal education greater than any other profession, a comparable profession?
Well, I'm not sure. No. I mean, it depends what you think of as a comparable profession. I would say the profession right now that has the worst crisis of debt is the veterinarians. And medical students also have a higher debt problem. The issue for us isn't so much just the level of debt for a graduate or professional school, it's the return on investment and the fact that the earnings of lawyers have stagnated and declined in recent years. So two things that I think that have come out of the work of the task force so far that are directly related to that are, first of all, one little idea that makes sense to me. Michigan does a great job on character and fitness right now, I think. I've been in different jurisdictions. Michigan, A+ from me on character and fitness. But we could, well, actually, we get an A++ if we would start that earlier. Let a student who's thinking about law school apply and get a provisional result as to their fitness to practice law before they put $1 into tuition. That way, if they have that opportunity, they won't be risking having to have $100,000 in debt and then not even be able to get a license. So that's an important point.
Congratulations, Dean Howarth. You effectively have addressed a question that wasn't even asked yet with respect to provisional approval of law students before they start investing in the educational process. We see a thumbs up from the audience that you addressed an issue that certainly deserves study and discussion. Well, I'd like to thank all of our panelists for your time, your expertise, and at this point, come on down with your name tags and your mug.